All right, there we go. And once again, let me officially welcome everyone to today's webinar, the Conservation Finance Forum, Lessons from Moosehead Lake. Today's event will be moderated by Jim Levitt, who's the Director of the Program on Conservation Innovation at the Harvard Forest. Jim.
Hello, Jim Cooney. Hello, Peter Howell and Ted Koffman, and hello, all of you. I can see by looking on my screen right now that there are 59 of us in this room, which is a big crowd for these Conservation Finance Forum sessions. I'm delighted to have you all, and I know we have a very interesting session for the next hour or so with these two gentlemen to think about lessons from Moosehead Lake. Before I introduce the two guests who are eminently qualified to talk about the topic, I want to set a ground rule or two and then give you a brief introduction to where we are in this situation right now. The ground rule, or the context, I guess, that I want to make clear to everyone is that we have not convened today to debate the decision made by the Land Use Regulatory Commission in Maine regarding Plum Creek's application to develop some land in the Moosehead Lake region. That decision is being vigorously debated in Maine right now. It will be debated during the appeal that has already been filed. And I know that there are advocates of both sides who are tuned in today listening to this conversation. So while that's all tremendously interesting, that's not our purpose today. The purpose today is to, in the context of what's happened around Plum Creek's application and the development process on Moosehead Lake, we want to think about what we might have learned from that process and how that informs us going forward in large-scale conservation projects, large-scale development projects, and how the two meet in such very important ways as they have in the Plum Creek process in the state of Maine. So given that framework, that we're here to think about lessons learned and how we go forward, let me set a little bit of background about the Plum Creek decision. And Jim Cooney, if you could give me internet slide 1, please. What we know is that the LERC decision on Plum Creek's proposal on Moosehead Lake was the most extensive in LERC's history, at least by its own report. This is a page that you see on your screen from the Land Use Regulatory Commission, and if you scroll down just a little bit, you can see that the decisions are there, and this record goes on and on and on. So all of the public documents are online for you to see. It's a process that's gone on for more than 3 years. It has taken up a lot of time and energy and thought on a lot of people who are acting in good faith on both sides of the question. The second slide, Jim, what we do know is that the proposal that was recently approved by the Land Use Regulatory Commission, yeah, that's it, is shown here on this map. This is a map provided by the Nature Conservancy, the Forest Society of Maine, and the AMC, and I show it here because I wanted to show the context of this landscape in Maine. You can see in the lower left-hand corner, the area enlarged is in western Maine, in the Moosehead Lake region, obviously. And Jim, if you would go to slide 3, we can get a little bit of a close-up on what this looks like from, that was recently published in the Bangor Daily News. It sort of highlights what's going on. So the areas in magenta or purple are the areas that there will be some development in. The areas in kind of a tan or brown shade are the areas that are intended for conservation directly associated with the decision, and the orange and the purple areas on both sides of the tan area are other areas that are going also to be conserved in the region at approximately the same time. So you have a sense of scale here. And Jim, somehow the image is is getting a little mixed up, but that's okay. You have it. There it is. You have a sense of the scale, and you can just leave it there for a minute, Jim, while I speak about the rest of this. We also know some basic facts about the decision, that Plum Creek first submitted the proposal in 2005 to rezone more than 400,000 acres of land in the Moosehead Lake region of Maine. And after 2 revisions, the last of which was submitted in 2007, as I understand it, a Plum Creek proposal was approved by LERC on September 23rd of this year. This plan allows for the development of more than 20,000 acres of land. That is roughly 5% of the total, and all of my numbers are rough and rounded. I know that there are several versions of these numbers that you can read from. And conservation within the proposal itself of more than 380,000 acres of land. That's roughly 95% of the total 400,000 acres of land. The conserved lands will allow for a mix of sustainable forestry, wildlife protection, and public access. We also know that Plum Creek, if it proceeds with the plan, which I understand is not certain, will build on as many as 975 house lots, and Plum Creek also will have the right to develop 2 vacation resorts in the area. The aggregate proposed project will be the largest single development in Maine's history. This decision, as I've intimated before, is being appealed by the Natural Resources Council of Maine, the Store of the North Woods, and the Forest Ecology Network. The Nature Conservancy has announced that it's going to argue in favor of the approved plan during the appeal process. One of the more contentious aspects of this project is that the resort on Lily Bay would be close to Canada lynx habitat, and that's a threatened species, and there's a lot of concern about that. In addition, the Nature Conservancy, the Forest Society of Maine, and the AMC, the Appalachian Mountain Club, have plans to pay Plum Creek over $30 million for 270,000 acres in easements and 2 land purchases of nearly 75,000 acres. In addition, Plum Creek will itself provide easements on approximately 90,000 acres of land. The fact that Plum Creek will be compensated for some of that conservation is also an issue that is a point of contention at present. Now, that brings me to the 2 speakers. Peter Howell, who works at the Open Space Institute in New York, was a lead author in an economic analysis of the proposal, and was quoted by several people as being instrumental in helping work to understand that regardless of whether or not Plum Creek's plan was approved, the company could, and I believe that this is of right, but I don't want to try to use a legal term here that I might not be exactly accurate, could have built on 25 lakes or ponds on its property even without a proposed plan, and that this approved plan allows Plum Creek to build homes and resort developments on only 6 lakes and ponds. Peter's biography is before you. I won't read through it, but he has been a key player in large conservation projects for some time now, and has worked at OSI, at the Doris Duke Charitable Foundation, and really is himself an expert in the field. Ted Koffman, who will speak after Peter, has recently been named as the executive director of the Maine Audubon Society, which is one of the oldest, or has roots in some of the oldest natural history organizations in the United States. Before Ted came to his position at Maine Audubon, he was for 8 years a member of the House of Representatives in the state of Maine, and for 6 years headed the, I guess was the House Chair of the Natural Resources Committee of the so Ted also has, and in addition to that, worked at the College of the Atlantic for more than 2 decades working on these issues. So Ted also has deep experience in the field and intimate knowledge of the conservation scene in Maine. Maine Audubon, while it is not in favor of LERC's ruling, is not going to join in the appeal of the decision, and has instead said that it will initiate a vigorous public discussion of what Maine Audubon considers to be the policy and process failures of the decision. Our goal, as stated by a Maine Audubon press release, is shared by thousands of people who live and work in and visit Maine. That is a conservation legacy for the North Woods that includes sustainable forestry, healthy communities, outdoor recreation, diverse wildlife species, and protected habitat. So we have two experts on the subject who don't always see exactly eye to eye on the process, but both have acted very honorably and in good faith and throughout this whole process to try to get to the state of Maine to a decision that is appropriate. And they will now talk about what they consider to be the lessons learned from this process and where we go from here. So with that, Peter Howell, let me turn it over to you.
Great. Thanks, Jim. I'm really pleased and honored to be a part of this effort, and thanks to Jim and his crew, and also pleased and honored to be paired with Ted, who has such a deep understanding of Maine and of its ecology and people. So let me just say a few things about OSI, why we became involved in this issue, and then go to the meat of the presentation. What are some lessons that we take? You can leave it here for a second. OSI is based in New York. We do three things. We acquire land and easements. We finance other land trusts to do the same from Maine to Georgia. And third, we conduct research on selected land conservation issues. For the last decade, we've had a pretty significant presence in the northern forest, having made about $50 million in loans and grants to land trusts to protect about 1.4 million acres of land across Maine, New Hampshire, and Vermont, and New York. And this was the era of large land sales by the big industrial companies. And throughout all of this, Plum Creek seemed to be following a different calculus. As an investment real estate trust, they really had a different set of financial interests and constraints than the old line industrial timber companies. And typically, for more detailed reasons that relate to how they treat income for their investors, REITs seek to maximize revenue from real estate development. And after several failed efforts to sell their land in traditional ways, Plum Creek embarked on this long and very challenging path of developing what's known as a concept plan and submit it before LERC. We became involved in this project for a couple of reasons. Under the LERC process, a concept plan enabled a landowner to lay out what they would do and to cluster or do more development and faster than they would normally be able to do in exchange for conserving land and providing land as sort of offsets. And so the issue for LERC was, how do you effectively balance that development with whatever conservation in a way that preserves the character of the jurisdiction? Now, we realized to do this, it was critical to understand what development and conservation are likely to occur without a region-wide concept plan, as Jim said. In other words, what could the company do if it were allowed to develop by the normal rules and regulations within LERC zoning? And because the question never was, would there be development? The question was rather, how much development would there be, and where would it or optimally should be located? And we realized that it was important to use all measures available, including financial metrics, to analyze whether that proposal meets balance. And I think secondly, we got involved because we realized that objective analysis might just help opponents and critics discover what could be potentially common interests, instead of carrying on a polarized fight. This was probably, and I'll defer to Ted and others, one of the most polarizing fights in the history of Maine's environmental history. And it was a costly one, continues to be. It was a divisive one that pitted various members of, and has pitted various members of the environmental community against one another. And it's been a long, long struggle. And the notion we thought of is there knowledge that could help groups find where they might come together? So we participated in this as an interested party, neither favoring nor opposing the plan. Next slide. Jim, next slide. I think Jim pointed out where the jurisdiction is, right in central Maine within the 10 million acre unincorporated territories that is the jurisdiction of LERC. Next slide. Again, next slide. I'll shoot ahead because Jim provided some of this. And this was the plan, as Jim pointed out. Next slide. Just a little bit of context here. This was, as Jim said, the largest proposal in Maine. It dwarfed any other concept plan that had been reviewed by LERC, 400,000 acres versus, I believe, 22 or 25. And even though Plum Creek had proposed to develop only 14 or 20, depending on how you count it, 1,000 acres, these were located on or near Moosehead Lake, an iconic landscape, and on various remote ponds. And so even though this was a small percentage of the overall landscape, it was very sensibly located. And as I said, the plan sparked a very divisive period. Next slide. I think you skipped one slide. Oh, no, you did not. We essentially wanted to look at how much development there would be. Actually, you did skip one slide. Can you go back one? Right. So the question is, did the plan achieve balance? To do this, we felt we had to answer three questions. How much, what kind of development was likely to occur without the plan, the baseline? Secondly, what amount and what kind of conservation was likely to occur under the baseline versus the plan? And third, what was the financial value of the concept plan? Next slide. In essence, we found, and these numbers are a little outdated because they were revised a little bit, but in essence we found that there was significant development that would occur under the baseline, about 618 lots versus 975. And there would be about 1,400 residential units versus 2,000, as you can see, and on the rest of those metrics, development on 25 ponds versus 6, and a fair amount of adjacent, actually fewer adjacent lands. The takeaway here was that there could be a fair amount of development, and that development could very well be chaotic. That is, located in various places around the jurisdiction. There was difference of opinion about how many acres could actually be developed. Plum Creek arrived at a very, very high number, of course, to make the case for the concept plan, and the advocacy groups tended to arrive at a very, very small number. We looked both legally at what could be developed as well as the trends. LERC generally had agreed with us that we struck what seemed to be a sensible middle ground, and the takeaway was significant. Do nothing, and there will be significant development throughout the jurisdiction. Next slide. But it's also important to look at how much conservation would occur in the baseline versus the concept plan. And here you have a comparison in terms of the amount on the shoreline, the amount of backland protection, trail corridors, and road easements. And the takeaway here was that there was not likely to be much conservation in the baseline. If the company develops without a plan, they're under no obligation to set aside land, and actually very little land would be technically conserved. And note here that we are excluding, and I'll get back to in a second, the land that was the subject of the deal with the Nature Conservancy and the Forest Society of Maine. We did not make this part of the analysis. That was sort of an additional benefit that might come with a plan. So the takeaway was that there would be a significant more conservation under the baseline. And to the third point, next slide. I won't go into this in great detail, but we basically constructed a financial model that tried to compare how much Plum Creek would make through these various options, the concept plan and the baseline. Next slide. And so we constructed a profit and loss statement that looked at exactly how much they would make. And basically, I think you skipped one slide, no? Yes. In essence, the takeaway was that under the baseline, under the concept plan, Plum Creek stood to make about $105 million from the mix of residential development in the lodges in Lily Bay. They stood to make about $67 million to the baseline. Why did they make less? The concept plan allowed them to build more and build more earlier on, such that the value of this plan to them was about $38 million. And it really turned on the next slide, Jim, which is green is the baseline. Sorry.
I apologize. For some reason.
Yeah, no, that's right. That's right. The concept plan is green, and essentially what this means is on the left axis is the amount of money in tens of millions, and on the bottom is years. And basically the company made more money, as shown by the green, because they were able to develop more money by building not only more units, but building those units earlier than they would able to build under the concept plan. And so this plan was worth a lot of money to Plum Creek. And our analysis basically showed that this financial revenue, the money that they earned, one could take away a couple of things from that. One could decide that the plan could be modified and development could be pared back and they could still make some money. Or one could decide this is just evil and one's making too much money and we ought to just scuttle the whole plan. Let's go to the lessons right now, which I want to focus on in the time that I have remaining, about 5 minutes. Striking a balance between conservation and development, which was LERC's primary challenge, is exceedingly difficult. What exactly is balance? How do we measure it? How do we account for the fact that different landscapes can bear, from an ecological point of view, different ratios of development to conservation? No landscape is the same. This is a very difficult issue that LERC struggled with. Various other forms of mitigation, like wetlands mitigation, have almost ironclad ratios. You destroy an acre of wetlands here, and you have to restore an acre over there. Would that LERC had such an easy job. They did not. There was no scientific rule or measure that allowed them to determine balance. They had to use the best available information that they had. Secondly, the road less traveled, not traveled, is always important. And we kept coming back to, and I think it's what several LERC commissioners cited in their decisions on this, which is, what could Plum Creek have done absent a concept plan? For us, that became instrumental. How much development was it? Where would it be located? How much permanent conservation would there be? To not address that question was, in our view, intellectually dishonest. I think a final question, another issue, is when do you pay for mitigation versus mandating it? We're going to talk, I'm sure, about the deal that Plum Creek struck with TNC and the Forest Society Maine and the Appalachian Mountain Club. This is a deal that they struck in principle before the plan was approved, and they're going to get paid for it. And so LERC actually initially said that's not part of the mitigation under the concept plan, because if you're getting paid for it, that's not part of it. And so they mandated the conservation that I described above, the 93,000 and the other trail corridors, independent of the paid deal. And we looked at this independent of the paid deal. In the end, LERC made the conservation deal that Plum Creek struck mandatory. In other words, under the agreement, Plum Creek must place an easement on those lands as they committed to do with TNC before they can develop an acre of land. And so in essence, what LERC did is that they made this conservation, which was theoretically optional and not part of the plan, they ended up making it required. Now, there'll be discussion certainly about, well, why do we have to pay for it, or should the public ever have to pay for it? But I think it's important to realize that that conservation is going to be required. And if TNC doesn't come up with the money, Plum Creek, in order to develop that land, must put an easement on that land, and in other words, it must pay for it itself. So we think, in essence, without judging the merits of that deal, that LERC actually did a terrific thing there, and that they ensured and guaranteed that that additional conservation be a part of the plan. Next slide. How much a landowner earns is not part of LERC's review criteria, and we made that very clear. But it defined what is feasible, and it shaped the negotiation in fundamental ways that I think create some lessons for LERC going forward. You can't compel a landowner, and particularly not here, to undertake a money-losing venture. In other words, if one had said, here's the concept plan you're allowed, and you must do it even though it loses you $10 million, Plum Creek always had another option, which is to say, well, take your concept plan, and we're going to develop according to the baseline. Conversely, you can always negotiate with a landowner who's earning a windfall. I want to be careful how I use that word. I don't want to make a judgment about how much money Plum Creek shareholders are going to make out of this plan. It's clear to us that they could make a significant amount, although the uncertainties over the real estate market today may cast some doubt on that. But the fact that there was a margin meant that one could modify the plan, restrict the development, increase the amount of conservation, and while it might shave money off Plum Creek's return, you could maybe take them down pretty far until they're indifferent between the plan and the baseline. And that really leads to the next point, is that balancing conservation development is not a science. It is fundamentally an art for the reasons I cited above. It is iterative. It by necessity requires negotiation to get to yes. This is a process that some, including those appealing the decision, have criticized by saying that under LERC strict regulations, you are to provide an up or down vote. You're not to negotiate. The modifications made were contrary to LERC's original statutes. I'm not a lawyer. I won't argue that point. But as a practical matter, I simply would observe that conservation at this scale, mixing conservation and development, is inherently iterative. I can't see how it's not. And in essence, what happened was a negotiation that we think reflected a mix of knowledge about ecology and knowledge about financial feasibility. The LERC consultants and staff modified that program in part because they could, because they knew they could drive from Plum Creek to make changes that would not financially drive them to ruin. And so an understanding of that financial framework, we thought, was essential to create some kind of compromise solution which we felt was probably in the best interest of the public. And again, I don't say one way or another whether the plan is right. Next slide. And so reasonable people will differ on whether this plan achieved the right balance. Did LERC push Plum Creek too much? Did LERC not push them enough? That question might be answered in multiple ways depending on your point of view. We don't come out either way on that. Our sense was that this objective analysis could help guide decision making, and I think it did in some respects, but there are such deep, deeply felt passions around this subject, and we respect them. We respect those who were in favor as well as those who are currently opposing and taking it to the Supreme Court. And ultimately, this is a matter of the heart, where reason can only venture so far. I think a major challenge going forward, as we reflect in closing, is how do we think about balancing, achieving balance throughout the remainder of the jurisdiction? This was the largest, the most contentious. Other landscapes may go forward more efficiently and quickly. We're not sure. The question of whether LERC has the right tools to, in effect, transfer development from those places it shouldn't develop to those it should, which is in essence what they tried to do in the Plum Creek proposal. We don't know the answer to that. There may be new tools, or it may be about letting the market develop on its own and finding ways to bring the next set of landowners forward that can build on and improve, because it is an iterative process, the balance in the process that was struck with LERC. And it's our hope that the concept plan is used in the future, because we think in principle it is a durable and effective tool to balance conservation and development, and we just need to work to make it better. Those are my thoughts.
Thank you, Peter. That was eloquent, well presented. I appreciate that very much. We will turn right now to Ted Koffman, who's going to speak on how he sees the process and how it might be improved going forward. And then we will take questions from all of you. So let me say to everyone who's listening, and I see there are 74 people in the room right now, 75, which is really impressive, that and I will try to speak more loudly. I understand that it's hard to hear me, so I will try to speak clearly into my microphone. Let me encourage the listeners to begin to go up and ask questions in the question section of your screen, so that I can ask them both of Ted and Peter after Ted has had a chance to make his remarks. So with that, Ted Koffman, can you give us your thoughts on the subject?
Yes, indeed. Well, thank you, Jim, for inviting Maine Audubon into this discussion. And thank you, Peter, for your perspective. I'm glad you went first. Of the 75 or so people who are listening in on this conversation, many of them have been involved intimately in this Plum Creek subdivision proposal process and are currently engaged in continued discussions at the level of the court. And Maine Audubon and I personally have good friends and colleagues whom we respect and I respect, with whom we have a difference of opinion about how the regulatory process worked or didn't work in this case. I would say at the end of the day that most of us would likely agree that important ecological lands in the region have been protected from development, as Peter pointed out, and certainly that economic opportunities will be created in an economically depressed area like Greenville. My remarks are going to be focused primarily on one particular aspect of the regulatory process that, in my opinion, needs to be corrected if we're going to treat Plum Creek as a model of how to go forward with projects of this nature. I think we can improve on it, and I think the public deserves that we improve on it. I'm going to attempt to make the case that the positive outcomes forecasted from this project may well have been achieved and perhaps exceeded if the conservation cart hadn't gotten ahead of the rezoning approval horse. As was noted by Jim, I served on the Natural Resources Committee, and I'm pretty well acquainted with at least the Department of Environmental Protection's approach to dealing with mitigation and compensation for major projects. Typically, project proposals that will take away or damage a public good, and in this case that might be recreational and ecological values, the developer must first demonstrate that he or she has made reasonable efforts to avoid damaging the resource. If that's not possible, they're expected to minimize damage to the resource. And then finally, if they have to really take the resource, the regulatory agency will then determine the extent of the loss to the resource and calculate a payment called compensation, at least at DEP, to help mitigate the loss. And that calculation has to do with the rarity of the resource, how hard it might be to replace, or the scale of the resource taken and the value of the resource for the public. And those calculations may not be precise. I think at DEP they actually have a formula that they apply and ratios that they apply. But at any rate, that helps shape the compensation package that will be required of the developer. And compensation can take different forms, from donating the land to preservation or by providing funds to the state, who will then go and purchase lands that have equivalent ecological value to the lands that are being taken for development. And if we could, it would be nice to look at the map of the Plum subdivision and rezoning that has been approved, if Jim can bring that up.
Cooney, if you could go to map.
I'll borrow Peter's slide.
It was on Peter's slides?
Yes.
On Peter's slides, yeah.
In the case of Plum Creek,
that's it.
There we go. In the case of Plum Creek, ongoing conservation negotiations between private parties, TNC and others, and Plum Creek eventually merged into the regulatory review process of the rezoning activity before ALERC had come to its conclusions about the merits of the actual subdivision proposal and the scale and character of the lake plan. And that merging of conservation negotiations, private negotiations, with the review of ALERC ended up, I think, in my view, potentially clouding around the merits of the project. Usually, in a DEP review, discussions about compensation and how that will take place, that is, how much land would be conserved and where it would be located, and how would it create an equivalency in terms of lost values to the public, that would all go on after the rezoning process had taken place. essentially it's a bit like you don't come out with the verdict in the sentence for someone in court accused of a crime before they've actually come to the conclusion that they're guilty of the crime. And so I think merging a pre-negotiated private conservation transaction with a regulatory determination of mitigation might not yield the most appropriate conservation package. And that I'm going to make the point that a tantalizing, exciting, much wanted over many years conservation opportunity would be challenging for me if I were a LERC commissioner or if I were on staff advising that commission. It would be challenging for me to separate the excitement over the potential conservation and the merits of the actual development project. And I think if the conservation discussion, the mitigation, compensation, conservation discussion, were to have taken place at the end of the finding, that is, LERC decides that the rezoning will be allowed, and then a rigorous discussion with all parties, including those who have negotiated or had put in place the potential of a negotiated conservation scheme. Others in the public could be involved in that discussion about compensation. Is it possible that the shape of the actual subdivision plan or the character of that plan might be different if compensation, conservation issues hadn't been merged during those deliberations? It'd be possible that by waiting to look at how Plum Creek would, others could be involved in shaping the look of that compensation plan. So surely many of the very prized, pristine places that CNC and others identified, and the state had done back in 1998 when it was interested in working with Plum Creek, but was not able to get a large land deal done, those wonderful places would have been central to a conservation plan. But it may also be possible that some additional value-added recommendations from others in the public could have actually improved the conservation plan at the end of the day. Now, people will argue, well, we couldn't have gotten as good a financial deal with lands if it weren't for the fact that Plum Creek wanted to get their deal in terms of development, so they in a sense surrendered value in order to get their deal. And all of that is, in my view, speculation. The important thing, from my perspective, is that we get this right in the future. And that's one of the reasons we chose not to appeal, but rather to try and work on improving the process so that next time around our friends in the conservation community and others can work together to make sure that projects that are proposed are the best they can be, and then the conservation mitigation compensation packages are all they should be, in that order.
Ted, I'm sorry to interrupt. This is Jim Cooney. I just wanted to make a note to our speakers that we're getting a periodic kind of whooshing sound. I'm not sure if it's the microphone, someone's microphone being moved, or someone breathing into the line. But just a note, if you're not speaking, please mute your phone. And then Ted, as you're speaking, I don't know if you're moving around your microphone or anything like that, but just be wary of that. Everyone should be wary of that sound.
Okay, good. Well, I'm just about to wrap up. As I've looked at this over the last several years and looked at the comprehensive land use plan that had been developed by LERC, when Plum Creek, well, let me step back. When 25 years or so ago, the mills began to sell off the woodlands that supplied the mills, and those lands began to be owned by a variety of owners who had a variety of ownership objectives, TIMOs and REITs. Plum Creek and its business model clearly would intend, if they were consistent with their model elsewhere, they would intend to develop some of their lands. And one of the lessons here for me is that had we, consistent with the comprehensive land use plan for that region, anticipated what conservation lands would be of most value to us prior to any applications, prior to any controversies, and begun to determine which lands would not be up for grabs and would not be acceptable for development. It might have helped avoid some of the conflict that we've run into. But given the fact that so many lands are now in non-mill hands, are not exclusively for forestry purposes, although many are, it's possible that we're going to see, maybe not on this scale, but on other scales in other places, projects that will challenge us. And I hope that the process we go through next time around is more careful to separate evaluating the project on the merits and then determining compensation afterwards. That's it.
Great. Thank you, Ted. That was equally eloquent and thoughtful. I want to invite now the members of the audience. There are some people I can see in this audience who have thought about these issues for a long, long time, so I'm sure there's excellent questions out there. To find the Q&A tab on the Microsoft Live meeting screen, to click on that tab and to, in the Q&A box, type in a question for the presenter. This is the best way for me to present the questions to our two panelists rather than in some other fashion. I have a Bart DeWolf, you've raised your hand but not asked any questions, so you might want to type in your question for me. For David Fox asked a first question, and I think there are probably some more coming, which is, for those of us outside of Maine, could one of the presenters give a brief background on LERC, their charter, and their makeup? And I will add to David's question, are there ideas about LERC's charter and their makeup and their process going forward that either of you would want to share with us right now? Either one of you can take that, Peter or Ted.
Well, Ted, do you want to take the LERC?
Yeah, I'll take some of the LERC.
Sure.
Others can chime in, and I know my friends who are listening in could do an encyclopedic job at this. But essentially, the LERC organization, the Land Use Regulation Commission, was put in place in the 1970s in response to concerns at the legislature and among conservationists that lands were vulnerable to sprawling recreation, second home development in the North Woods, which were largely privately owned lands and continue to be. So for those in India or elsewhere, we're talking about 40% of the state, which is largely in private hands, for over 200 years used for forestry purposes. And so concerns were growing as transportation had improved, as a road system had been developed to carry logs through the woods. Thousands of miles of roads made places that had been inaccessible to everyday middle-income people very accessible. And concerns were about haphazard development that would degrade the resource. And so this is essentially a planning board that puts in place a comprehensive land use plan that encourages development in already developed areas like Greenville at Moosehead Lake or like Millinocket. And Mission has been particularly challenged in the last years or so with reductions in budget and workforce. But they have a very, very challenging job, and of course this project probably is historic in the amount of resources it's taken and the commitment of staff time and commission time. But they are the agency that make decisions around 10 million acres in terms of land use, and it's a big job and getting all the more complicated because of the change in end-use ownerships that I mentioned earlier.
Only thing I'd add to that, and there are those on this call that know a lot more about this than I do, is that LERC is challenged by lack of capacity and staff and funding, and in some ways the Plum Creek affair highlighted that. Plum Creek paid for a huge amount of money to put their plan together and to do various analysis, and in some ways they got in front of the agency itself, which has these things called community comprehensive land use plans, or CLUPs, that they do for selected regions. They hadn't done one for the Moosehead region. One of the criticisms was that they should have done that first before they looked at a big, huge proposal for it that essentially encompassed most of the region. And in fact, Plum Creek ended up doing its own plan with more capacity and resources. Perhaps LERC could have done that first. They are doing those in other areas, and they need resources that often they don't have. I think a second issue that LERC needs to think about, and they flagged it, is the use of flexible incentives within their regulatory framework, otherwise known as trading and development rights programs in other jurisdictions. There is a recognition of the need to use such tools in a more flexible way, but working it out and making it cohere with LERC's regulations is obviously a challenge.
I'll just add a little bit to those listeners who aren't familiar with Maine. As you may have picked up, the land that Plum Creek purchased back in the late 90s was zoned at the time, and largely still is, for forestry use for growing trees. And that's been true for most of the LERC territories. Essentially, LERC is there in place to protect those forest resources and to provide opportunities for public recreation, and including remote recreation in areas that are undisturbed by roads and other problems and noise and that sort of thing. So it has multiple objectives, and a project of this scale in a state that has had a long tradition of public access to private lands, that presents another element in terms of the compensation issue.
And a big issue, not to go on, is that as the timber economy changes and those landowners come under some distress, the question is what will happen in the future of that jurisdiction? How much timbering will go on? How will landowners seek to monetize their assets like Plum Creek did through some mix of development, and where should that go? And these are very, very challenging questions for LERC.
I have
they're very challenging questions to the state of Maine.
Right.
And I'm very hopeful that leadership in various sectors, including the forest products industry and landowners, will look to define a preferred future for the North Maine woods that retains profitability for landowners, but help prevent going to the resort of having to subdivide lands on lakes and ponds and riverfront. I like Massachusetts, but if you drive through Massachusetts and New Hampshire to our south, there isn't much left that you could call remote, like we have in Maine. And I think it's iconic. It's part of our brand as a state, and we need to work with everyone in the Maine community to make that, as an undeveloped forest, work for all of us.
Ted and Peter, I have another question here from Jenny Russell. Jenny asked several questions. I'm going to start with the one in the middle, which is, to what degree does LERC have to recognize this vote as a precedent for future proposals?
Well, Peter, do you want to start?
Sure. Well, it does become a precedent. Absolutely, it doesn't become an ironclad precedent. And I think there are certain things that LERC evolved here. They developed real specificity in the easement, for example, that was required as a condition with TNC. They developed design parameters and design specs on the development. So there are actually some very specific features of this decision that will become precedent and will guide the consideration of other proposals. I think Plum Creek was something of an oddity given the size of this landscape that was coming into the concept plan, and given that there was some land that was extraordinarily valuable for development and some land that was not valued at much because it was all backcountry. You don't have that many large landscapes that incorporate that diversity of potential uses the way the Plum Creek lands did. So there are, how much of these will be transportable, I'm not sure. But as far as the ratio of development to sort of conservation in the program, it has established a pretty high bar for conservation. In other words, the ratio of land developed is very, very small. So that actually may be tweaked in the future.
I have a...
can I answer Jenny's question a little bit, too? It seems to me that there are elements here of a precedent that we want to avoid and not let it be a precedent in the future. And I've tried to articulate one, which is to put the discussions about conservation to the end of the process deliberating a rezoning, which in most instances, I suspect, will be required. That is, this is land zoned for forestry being taken out of that function and put into development, which is, of course, more or less permanent until the next glacier comes. So we would strenuously try and avoid repeating the process we've just been through in that regard. I mean, you could imagine if there were not just one or two, but 5 or 6 contending private interests trying to work land deals just as the large landowner decides to put in a request for a subdivision. I mean, it can really get quite messy and sort of cast a shadow of doubt over the objectivity of the evaluation of the project on its merits against, tantalizing conservation opportunities, which should come and should be achieved, but I think need to be achieved in a different way.
Let me just respond to that, Jim, for one sec, which is, I think it's important to clarify, not to defend LERC or TNC or FSM, that LERC actually, you're making an assertion that LERC was influenced by this proposed voluntary deal. My sense is that LERC proceeded very independent of that and viewed that deal as a purely speculative voluntary transaction that was not part of the regulatory consideration. And the fact that at the end they made that a requirement, to me, was sort of a benefit. But I think they proceeded in considering this independent of that. Now, a landowner can do anything they want, Ted. I mean, if a landowner forms signs a purchase and sale agreement or proposes a discussion around protecting land, I'm not sure that the regulatory process can inhibit that. I think the best it can do is to be clear-minded and focused on exactly what the proposal is and what they're going to regulate and require. And I think in general LERC followed that. And I'm not sure how you're going to prevent sort of voluntary deals that are speculative or proposed from being discussed or occurring.
Well, that's a fair point. I was thinking the other day, what if the Plum Creek conservation deal had gone through and settled and paid for and the job was done? We'd all be celebrating. But having the deal in process during a regulatory process and then pulling that deal in, which is what they did, into the process and merging it with the process, I think begins to, confuse and cloud the thinking about what ultimately would have been both a better, perhaps, development scheme and a more, perhaps, generous conservation mitigation
gentlemen, I'm going to jump in.
Requirement.
Ted, I'm going to jump in and ask another question from Jay Espy, and I think it's pertinent to what you've both been talking about right now, which is, to what extent has the economic downturn impacted OSI's financial model, or perhaps Plum Creek's financial model, and what might the impact on Plum Creek's plans moving forward be? I don't know if either one of you can speculate on the impact of the economic downturn.
On future landowners?
Or on what the parties might do going forward.
Oh, well, I think it's speculative. Unless there's someone from Plum Creek here that would like to weigh in, it's unclear what and when and how they'll proceed.
Right.
But clearly the downturn has made some of the financial projections probably a lot less rosy.
Okay. Ted, do you want to add anything to that?
Only that it was our understanding that Plum Creek would not likely try and proceed with much development until the market improves. And we know that there are a number of lots on Moosehead Lake and subdivisions, of course, small subdivisions that have not had many buyers, in some cases no buyers, over years now that those subdivisions along the lake have been approved. So it's hard to say how things will unfold. But we'll learn a lot, and I accept that some terrific development strategies have been employed and developed in this process. So there's some lessons and positive lessons, I'm sure, to be learned through it all. This is a 30-year development plan, and there's a lot that can change, as we all know, over a 30-year period.
Okay. I've got a couple more questions. We're going to go. Usually we only go for an hour on these, but I've got a flood of questions. I'm going to read a couple more. One's a comment, actually. So for those of you who need to sign off, we understand, but we're going to take this to about 12:10 or 12:15. Being on the internet, we don't have any network constricting us. I have a comment here from Mike Petro, who is with TNC. He says that this is an important and critical conversation, and we appreciate hearing that from you, but it needs broader representation of stakeholders to be effective. On behalf of TNC, we welcome a broader conversation with full representation. We would also, we would also like to point out that there's a lot more complex, that this is a lot more complex than has been presented here. Assumptions about Plum Creek's perspective have been presented without verification. Listeners may be interested to know that the state of Maine had tried for a decade to negotiate a conservation deal with Plum Creek without success, and that the paid mitigation, quote unquote, was in reality a deep bargain sale, with TNC paying less than half of the appraised market value. Any comment on that statement from either of you?
I mean, Mike is absolutely accurate. Plum Creek was notoriously difficult to negotiate with. The state of Maine, various other conservation groups were unable to cut a deal. It's also absolutely true that much of this land, the easement and the fee lands, were bought at deep bargains, deep discounts off appraised values, so that the public is getting, in my view, as I stated before, as part of this plan, a kind of Benny. They're getting this additional paid mitigation that's largely being paid for privately at a deep discount, in addition to the conservation mitigation that was negotiated from work that I cited in my slides. So I think Petrol's point is absolutely correct. You know, there is the point that Ted keeps raising about, well, confusing and conflating these two deals. Well, conflated, it probably leads to a huge amount of conservation and all the conservation and more that people ever wanted in that region. That is, I don't think they missed anything that was a priority from the past. So they kind of got a lot in addition to the concept plan. There's arguably an issue about whether TNC and AMC and FSM helped to green up Plum Creek by forging a deal beforehand. Clearly, Plum Creek benefited from the association by announcing this deal in the midst of the negotiations. But I'd assert again that this is what people can do. This is how the voluntary markets work. If landowners and land buyers want to reach a deal, they can. I think also the work kept pretty clear what they would look at, and the assertion that they were clouded to me is interesting. I take it, but it's kind of a speculative assertion.
Ted.
I just want to echo Mike Petro's sentiments regarding getting a wider conversation going to see if we can improve on this process, even if we enjoy the benefits of what was accomplished, and I will look forward to being a part of that conversation.
And Mike, we wanted to open a conversation. Obviously, we're not going to conclude anything here, and I appreciate your comment. I also want to say that the speakers, of course, are responsible for their own opinions, and we're just glad to have them here to be part of this discussion. All right, I will ask one last question from David Strynek, I believe is how you pronounce his name, and it's kind of a broad question, but I like it, which is, for our work on identifying and spreading environmental and conservation innovations worldwide, what are the one or two completely new approaches or ideas that have resulted from this extensive chain of events? Have any replicable new ideas or approaches to the financing, to the legal, to the compensation, or other elements resulted from this process?
You want to go, Ted?
Just one, because I confess I don't have the intimacy you do, Peter, in this, so I'll turn to you. But one of the things that I was impressed with was the effort on the part of LERC staff to design the development so that places that were to be developed would be covered by protected, conserved lands, which would then prevent further spreading through adjacency rules, would not spread and create the kind of sprawl or extend the kind of sprawl that many of us are concerned with and that LERC in the first place is supposed to try and prevent. So I thought that was very thoughtful, and if that technique were applied for the last 20 years in lots of parts of Maine, we'd have a very different looking state.
Yeah, I agree. I think some of the design standards that are generally under the radar and haven't been talked about a lot may be very innovative in setting some standards and precedents for going forward. And some of them are as simple as where development gets sited, what its relationship is to sight lines. Plum Creek was very adamant that they have sight lines, property placed right on the lake. This is a hugely sensitive issue for people in Maine, and I think LERC did a painstaking job in moving some of that back. Some of it went up the hills so that they got views, from higher up. But I think they really respected the remoteness of ponds and the shoreline, which was such a critical issue to Mainers, and that may be one of the most significant and maybe more local precedents that get set. And I encourage folks to really look at what they did. They did an enormous amount of study, and they used a lot of the money that Plum Creek funded to do things that Plum Creek hadn't really proposed. I think, secondly, there will be some kind of innovation, but I think with Ted and others, we're going to sort this out over time, which is how do you link paid mitigation, even at a discount, as Mike Petro has pointed out, ideally at a discount, to the sort of required mitigation that may be regulated. My sense is going forward that there will be other landowners that will seek some kind of hybrid of paid mitigation combined with regulated mitigation, and I think there could be some innovation here. Not sure exactly what it is yet. Ted raises some great points, but I think there's some relationship here that may be innovative for the rest of the country.
Very good.
I'll just add one other quick thought, that Plum Creek has certainly inspired us, I think all of us, to begin thinking big, not just one project at a time, but to look at the resource as a whole in a more comprehensive or holistic way, and not waiting to react to the next proposal, but to think ahead and about the vision we have for the North Woods. And that we need a master plan review of resort areas and other large development sites, so we have a sense of where things might be appropriately cited. My friend Evan Rickert, who worked with the LERC Commission, has been an advocate of pre-planning, of thinking ahead of what you'd like to see rather than wait for someone to make a proposal and then react to it. And a master plan review is really required for these sorts of areas, and so I think we can continue to make some progress in the future working together.
All right. Well, I want to thank both of the speakers and all of the people in the audience, many of whom I know, for being here for the last hour and 15 minutes. This has been a really interesting and provocative discussion. I think it's brought a lot of issues to light, and I think that there is quite a bit of work to do on conserving and developing the North Woods and finding the right balance between the two as we go forward. So with that, I want to thank you all. Wish you
thank you, Jim, and Peter.
You're very welcome, and happy holidays to you all, and we'll be back with another session of this dialogue in the first quarter of 2010. All right. Bye-bye.
Thanks, Jim.
Bye.
Bye-bye.